Welcome back to Outside Counsel. I'm your host, Jeffrey B. Simon. I get a ton of DMs on social media asking for advice or explanations on a topic discussed on the podcast. So I thought I'd handpick a few great questions and answer them here in a special Ask Me Anything episode on Outside Counsel.
How do you think public opinion influences the trajectory of abortion laws in the U.S.?
By how Americans vote in elections. Every relevant poll on the topic shows that most Americans believe abortion is a private medical decision between a pregnant person and their doctor, and that access to the procedure should be legal. Even among those who believe abortion access should be limited to the contours described in the case of Roe v. Wade, which it was for 50 years, believe that criminal penalties should not be imposed for later term abortions. And that majority will is demonstrating its force in elections. Even in very red states like Kansas and Ohio, constitutional referendums to guarantee access to abortion passed resoundingly. In many respects, the religious right, who fought for a repeal of abortion rights for half a century and then finally got it, is looking more and more like the dog that caught the car.
What impact do you think changes in the composition of the U.S. Supreme Court have had on abortion laws and the broader reproductive rights landscape?
Absolutely everything. All three justices for the Supreme Court selected by then President Trump. So we're talking about Justices Gorsuch, Kavanaugh, and Coney Barrett, were selected by him specifically because they were committed to overturning Roe v. Wade, which he had promised during the 2016 campaign, if president, he would ensure happened. Now, those justices, when they were up for their Senate confirmations, were not candid, but they intended to overturn Roe v. Wade. One Democratic senator told me he knew that one of the nominees was lying to his face in his office. But both he and the nominee knew that the GOP had the votes to confirm that person anyway. And the repeal of Roe versus Wade and the Dobbs decision broke with Supreme Court tradition that is centuries old, called stare decisis. By that doctrine, the Supreme Court declines to disturb, that is, overrule, long-standing precedent because people have come to rely upon it as the rule of law. Even if going back in time, if we could do a time machine, the court as currently constituted would have decided the case differently. In my view, this Supreme Court, the majority, scrapped its tradition of stare decisis and the precedent of Roe v. Wade for purely political reasons, rather than as a result of some change in law or underlying facts. And when they did so, they tarnished the court's image and people's confidence in it and our system of laws very badly. The decision to overturn Roe versus Wade, simply because different people were on the court than there were in 1973 when Roe was decided, reinforced something I've known for a long time that people should understand. There is no law, there is no tradition in America so sacred that it cannot be taken away from you. There are always going to be powerful groups who are interested in depriving you of some right because it competes with their own desires. And consequently, you should vote. And you should vote for people who will uphold systems of law and traditions as you know them and rely on them.
Do you feel that the media landscape has changed so drastically in order to fit a particular narrative? Do you believe media is dangerous to American citizens?
Misinformation is dangerous to American citizens, and some media outlets fuel it. Now, there can be a price to pay for the purveyors of misinformation as well. like Fox paying nearly $800 million to settle a defamation case over Dominion voting machines.
What types of mass tort litigation cases are likely to succeed and which aren't?
That is a really great question, and one that has been studied anatomically. There is an esteemed law professor named Timothy Litton who wrote a paper a few years back published in the Texas Law Review, where he examined what types of mass tort litigation have succeeded in terms of the objectives of the claimants and which ones have failed and why. And he came up with a rather elegant and demonstrable analysis where he concluded that basically mass tort litigation succeeds or fails depending upon the presence or absence of about 4 factors. For mass tort litigation to be likely to succeed, number 1, there needs to be consensus outrage in the public about the claimed wrongdoing. In other words, when the public learns about the nature of this mass tort litigation, they need to be outraged by the conduct alleged. 2, the plaintiffs in the first few cases in mass tort litigation, that particular segment of it, need to have some success in trials or in obtaining settlements which are positively covered by the press. In other words, the press treats the coverage of the trial outcome, the win, or the money that was obtained by settlement as justice being done, rather than some windfall to the claimants or their lawyers. 3, there needs to be a perception that intensifies the consensus outrage, which is that the defendant has been unwilling to reform voluntarily. Only getting busted in litigation forced them to modify their business or institutional behavior. In other words, the only thing that changed the outcome in terms of what they did next, reform, was getting caught publicly, having juries take a dim view of it, and them having to pay a bunch of money because of their wrongdoing. And that lastly, the litigation itself, in terms of its objectives, complements rather than competes with the goals of other policy-making institutions, like regulatory agencies or legislative bodies. Examples he provides to demonstrate this contrast, where those factors were present and mass tort litigation succeeded versus where they weren't and mass tort litigation failed, is the distinction he draws between the success of the litigation involving clergy sex abuse in the 1980s and 90s and early 2000s versus the outcome of litigation against the gun industry involving gun violence. Litton argues that the clergy sex abuse cases benefited from all of the 4 factors, while the lawsuits against gun manufacturers were less buoyed by them. He cites, for example, that when news of the clergy sex abuse cases was covered in the press in the 1980s, people were outraged. There was not a broad public understanding at that time that there were priests who were pedophiles raping underage parishioners. And when the litigation exposed that fact, people were outraged. And so when they got verdicts against the church and against priests who engaged in this unimaginably awful behavior, the press celebrated it and people cheered. Justice was done. Moreover, part of the narrative was that the church had been covering up for priests, that the Catholic Church had been simply sending priests who they knew to be pedophiles to different parishes, rather than kicking them out of the church and reporting them to law enforcement. So you had that cover up condition that intensified public outrage, he argues. And lastly, the results legislatively, changes in policy and law that litigation spurred were met with acceptance both by lawmakers and the public. For example, statutes of limitations were extended so that people who had been raped as children but were now adults could still bring claims. And the criminal penalties for pedophilia were strengthened in many jurisdictions, again, as a result of the public outrage resulting from the litigation and the public shame upon the church and priests that it created. Then he makes the point that what happened in terms of gun litigation was very different. That in the 1980s and in the 1990s, various governmental entities brought cases against the gun industry, especially in the arena of public nuisance, where they claimed that the gun industry had responsibility for selling too many guns and recklessly promoting them, and that as a result, gun violence went up, which caused not just enormous human suffering, but a large economic burden upon these communities, and that the gun industry should be held financially accountable for that fact. Well, the causal relationship between gun violence and gun industry liability was not nearly as clear to the public. We all know the expression, guns don't kill people, people kill people. And that's part of the Second Amendment rhetoric, especially from the gun industry. Now, ownership of guns is protected by the Constitution, but manufacturing and promotion of it, at least recklessly, is not. Nonetheless, the gun industry did a very good job of blurring that line. They convinced lawmakers that civil justice cases against them were expensive, and they were affecting their ability to provide guns to the public who had a constitutional right to obtain them. Not only that, they convinced lawmakers that, hey, they're trying, these plaintiffs' lawyers, these communities that have hired them, are trying to achieve outcomes through civil litigation that are not only violative of the Second Amendment, but they can't get passed as laws in their communities. In other words, they're circumventing the lawmaking process by using the civil justice system in some sneaky way. So whereas with respect to the clergy sexual abuse cases, plaintiffs' lawyers were deemed as heroic whistleblowers of a terrible scandal and a terrible harm, in relation to cases against the gun industry, plaintiffs' lawyers were viewed as people who were trying to be sneaky in the way they use the civil justice system to circumvent the lawmaking process and infringe upon the constitutional right of Americans to bear arms. Whether that's true or false is not material, because that is what happened. And not only that, there just simply wasn't public outrage at that time in the 80s or 90s at the gun industry about gun violence. Again, the perception being that the shooter is more responsible than the gun industry. And so what are we really talking about here anyway? And the result of all those things was that the gun industry was very successful in using its political influence to get a law passed in 2005 that immunizes the gun industry from almost any kind of case in the civil justice system arising out of gun violence. As a result of having done that, there are 4 times as many guns in America today as there were in 2005, because the gun industry can manufacture and promote guns almost however they wish without fear of exposure in the civil justice system. But times may be changing. Since Litton wrote that paper some years ago, there has been a shift in public sentiment about the utility of tort litigation to curb gun violence. Several of the parents who lost children in the shooting at Sandy Hook Elementary in Connecticut won a large settlement from a gun manufacturer. And both press and public sentiment lauded that outcome. Even among people who believe very strongly in the right to bear arms, there was a sense that we've gone too far. The wrong people are getting their hands on guns too often. And the ease with which people can obtain weapons that were developed for use in war, but are marketed to civilians as, for example, a means of reaffirming their masculinity, is offensive to more people now than it was in the past. Several legal observers, including me in my book, Last Rights, have argued for congressional appeal of that law passed in 2005, which is called the Protection of Lawful Commerce in Arms Act, that gives the gun industry almost total immunity in the civil justice system. My book, along with other opinion pieces on that topic, have received critical praise and have perhaps galvanized some political traction, especially if Democrats were to gain control of the House, because they have given voice to the need to repeal that immunity law. There is no reason that the gun industry should have special protection to commit wrongdoing that manufacturers of other products in America don't have. Remember, gun ownership is protected by the Constitution, but reckless promotion to civilians of high-powered rifles designed for war is not.
Hey Jeffrey, impressive background. The intersection of corporate greed and political power can indeed pose challenges to a fair justice system. What do you think are the biggest challenges?
Lack of awareness among the general electorate that so-called tort reform is not reform at all. It's corporate power with political influence that uses their power and influence to take away consumer rights or further harm our communities with legal impunity. Tort reform is almost always intended to make the powerful even more so and the injured even more powerless. We need to collectively wake up to this scam and elect only candidates for office who will protect the civil justice system and expand rather than reduce consumer protection and the rights of medical patients.
I am frustrated with the justice system because I wonder how just it really is. In our city, gun violence is on the rise. Innocent people are being murdered senselessly just because they move over one lane in front of someone. I want to know why the perpetrators get away with a tap on the knuckles. Why are their bonds so low? Who does it benefit to have a continuation of criminal get-out-of-jail passes?
Weaker gun laws lead to more gun violence. Too many criminally minded or reckless people get their hands on guns when they shouldn't. There are more guns in circulation in America than there are people. We have approximately 330 million Americans. There are approximately 413 million guns in America. That much glut of guns, coupled with weak laws, make them too easy to obtain. Rifles that were made to kill enemy combatants in a field of war can be lawfully sold to almost anyone who has the money to pay for them, and as many as they want. That leads to mass gun violence, as much or more as anything else.
I'm currently fighting the DEA on behalf of 3 academic researchers regarding a very suspect move to add an important research chemical to Schedule 1. This has the potential to seriously curtail research into new psychedelic drugs and broader research into the underlying mechanisms on how serotonin receptors work. The DEA is doing this despite not even one report of a death or even a single emergency room visit in 40 years of scientific research, yet they claim to need to place this drug in the most restricted class. It is interesting to note that this is the very last unscheduled 5-HT2A serotonin receptor agonist available for research. The 5-HT2A receptor is the primary receptor believed responsible for the effects of classical psychedelics. No deaths, not a drug of abuse, critical for research into psychedelics. Why are they pushing hard for rescheduling?
I don't know all of those details independently, but I agree that not all drugs that are Schedule 1 should be. The designation of Schedule 1 is for highly addictive drugs with no therapeutic benefit. Marijuana is not nearly as addictive as other Schedule 1 drugs, but it is Schedule 1. And it undoubtedly has medical benefits to manage pain, anxiety, or nausea for many patients. The simple fact of the matter is that alcohol is legal in America. Marijuana is not only illegal federally, it is Schedule 1. And it is scientifically unjustifiable that it is. So I guess what I would say is I'm not surprised that a mistake may have been made again with respect to another drug, because the Schedule 1 classification for marijuana is nonsensical.
Our nation started its deep decline when we changed our taxation to reward those who put corporate profits and Wall Street compensations before their workers and our country. Our wealth gap has created a crazy level of global corruption and has poisoned our judicial and political systems. Citizens United needs to be overturned. Church and state needs to be fully separated, funneling money through nonprofit fundraisers. Political donations need complete transparency. Gerrymandering needs to be squashed on all sides. SCOTUS needs deep investigative dives. Americans need to be able to buy their own homes. Private equity firms, speculators, controlling market, and healthcare needs to be affordable and free by getting corporate greed out of the equation. And state-accredited colleges need to be funded and free for students. This is not our first rodeo in America. We have seen this many times before, terribly in our history, and we know how to fix it. What are your thoughts on this issue?
Well, how much time have you got? And get your popcorn ready. I mean, I agree that enormous wealth disparity in America is harmful and is not a necessary output of capitalism or a free America. We have in our Constitution a mandate for a progressive tax code, but in practice, our taxes are too often regressive. Billionaires shouldn't pay less in taxes, either as a percentage of income or in total dollars, than do their secretaries or the teachers in their kids' schools, but they often do. Reforming the tax code to ensure that it is progressive, rather than a boon to America's most wealthy, would be a very important start to addressing wealth disparity and would not violate anyone's rights. Also, America's current healthcare system is more expensive and less efficient than it would be if there were a public option. Those that call having a public option for healthcare socialism are ignoring the fact that in this great democracy of ours, taxpayers already pay for the healthcare of veterans and people on Medicare or Medicaid. People should stop pretending that extending those healthcare services to every American, if they choose to use it, is undemocratic. The truth is, it would save more lives and money over time than the system we have, where the indigent show up in emergency rooms with expensive and life-threatening diseases that could have been avoided if they had access to preventative health care. Lack of access to health care costs taxpayers more money, not less.
Do you have any updated thoughts regarding immigrants to the United States and the status of immigration laws?
I don't consider myself an expert in immigration, but I do know a lot about climate change. And that's relevant to your question. Climate change directly affects immigration volume into the United States. As the Earth's temperature rises, it dries out soil and kills crops, which affect both agricultural output and food security, especially in poor nations with agrarian economies like many countries in Central America. While political powers in Washington, D.C. fight over immigration policy and use it as an animating issue to voters in elections, very few elected officials talk candidly about the root causes of mass immigration to the United States and how we should direct policies at addressing the matter at its essence.
My brother died in January 2006 after he saw a primary care physician for the first time, and that doctor prescribed him morphine without getting any previous records or talking to his doctors or anything. My parents were told back then that they'd lose a lawsuit, and no one wanted to take a case like that. I assume it's past the statute of limitations, but why is the state and government able to sue the drug manufacturer and collect money when my parents couldn't sue a negligent doctor or anyone?
Wow, I am so sorry for your loss. I can tell you that unfortunately what you described is the hallmark of the first phase of America's opioid epidemic, the period that began in the late 1990s, where physicians began overprescribing opioids to patients with pain because drug manufacturer propaganda, disguised as best healthcare practices, infiltrated every level of medical school training and continuing medical education. It's true that the statute of limitations likely expired long ago in the events you described because they took place in 2006, and limitations periods typically range from 2 to 4 years, depending upon the state and the nature of the claim. Now, governmental entities are suing opioid drug companies, as you point out, but for a different type of claim than the wrongful death case you described. They're suing for recoveries of monies expended and likely to be expended to fight the opioid epidemic, taxpayer money. The statute of limitations that applies to governmental entities differs from ones that apply to patients, and sometimes not at all. For example, a patient cannot bring a claim for public nuisance, but a governmental entity can. In many states, there are no time bars to bringing a public nuisance claim so long as the nuisance continues. And for the most part, that is the distinction with the difference that goes to the heart of your question. Thank you, everyone, for sending me your questions. If you have a question or some feedback for me, please find me on social media at Jeffrey B. Simon. This podcast is produced by Shannon McDees of Revel and Convey and Larry Shavana. The opinions expressed on Outside Counsel are neither legal nor medical advice. The views and opinions expressed in this podcast are those of the speakers, guests, experts, and/or host. They do not expressly nor necessarily reflect the opinion of any institution with which I am or ever have been a member and should never be attributed as such. Thank you for tuning in to another episode of Outside Counsel. I'm Jeffrey B. Simon.